I'm going to call the work session for the Board of Commissioners to order for January the 3rd, 2011. I'd like to welcome everybody back to the new year. And we have today, the agenda that's before us. Do we have a motion to approve the agenda as presented today? And included in that motion would be to transfer the consent agenda that's before us listed onto the consent agenda for January the 17th.
So moved.
We have a second? We have a motion, we have a second. All in favor say aye.
Aye.
All opposed, motion carries. First that we have to at least get some update on before the 17th is under old business, the resolution pertaining to the future of the animal shelter in Cabarrus County. I believe that was tabled from December till today.
Was it today?
Just for the understanding that we're on progress to at least look at the resolution come the 17th, I believe, is what we were talking about in December.
The meeting, the APAC meeting is next Monday night, the 10th, and after that meeting, we'll have more, the final resolution to give to you guys. So I'll email that once I get through with that meeting next week. I want to thank Commissioner Meismer for some research he did great on some of the other shelters in the area and what they're doing. And then Mr. Burge also brought some material in tonight from several years ago where we were doing some reorganization as well. His wife was on the committee then to help with that. So I'm looking forward to looking at some of that stuff as well. So.
Okay, I think that if the APAC committee approves the resolution as presented to them, which would be the same one we have, if you can make certain all of us know so that we know what we're discussing on the 17th, and if there's anything changed, then as well as to make those modifications so that we can get an understanding about where the discussion is going to head from there.
Okay.
Thank you, Commissioner Pruitt. Under G1 is commerce. That is found on page 21 of our agenda. This is the APFO Voluntary Mitigation Payment Adjustment for 2011. This time I call on Mrs. Morse for a presentation.
To the voluntary mitigation payments. In your materials, you had the information from the last, since 2008, so the last 3 years, what the adjustments have been. Last year, the percentage that was used was 60.572%, which is the current adopted policy. So what you have in front of you is the original amount from the Tischler Weiss study per seat per student, and then the amount for the voluntary mitigation payment based on the index adjustment for 2010. And you can see that based on the cost of construction, it is suggested that the voluntary mitigation payment be increased. The cost of construction has gone down, but apparently the cost of construction materials has not. So I did work with the tax department on these numbers, and that's what they said that they're seeing, and that's what the reval office is seeing. So based on 65%, 60%, 55%, and 50%, you have those numbers there for single family, townhome, and then multifamily or other. And the ordinance does call for us to make this adjustment in January of each year. I'd be happy to answer any questions you may have.
Any questions for Mrs. Morris? What is the...
I mean, just a comment. Last year, didn't we leave it the same instead of making any change? We made a decision just to leave it flat.
We adjusted the percentage to try to keep it about the same, yes.
And I believe the reason we did that was because of the recession and the decrease in building. Would that be, I don't know if Commissioner White or...
Mm-hmm. Yes, that was.
Correct.
Yes, and last year, the mitigation amount actually was decreased based on the construction index.
I think that we need to take a serious look as to whether or not we move forward with the APFO as a whole. I mean, at this point in time, I'm have no problems with getting rid of it as a whole and just not do anything further with it, or abolishing it and getting rid of it, however you want to say it. I'm in that position right now. I don't know what needs to be done between now and, well, how long it would take for us to, for staff to look at it to see what kind of problems that would propose or incur.
At this point, I might just suggest that you table it to some period in the future, and while we do some research and while there's some other issues that you discussed recently in closed session that should be pursued.
Yeah,
Right.
I was going to echo your comments. Tabling it for 3 months, do you think that would be a
That's fine.
fair?
Okay.
is that-
Why don't, we have a motion to take, or any other discussion?
You said that the mitigation payment went down last year from the year before. How much did it go down?
Last year, based on the amount for the actual amount for, it went down by about $2,000. And there's a spreadsheet that you have in your packet that kind of shows you what that amount would call for. So originally, we started out at about $13,000 per seat. Then the second adjustment that we did in January of 2009, it was around $14,000 per seat. Then last year, it adjusted down to $12,000 based on the construction index. And then this year, it is actually adjusting up to the 13. And that's based on the Marshall and Swift. It's a construction index that they use to value buildings and on the type of construction materials used.
Is there any other discussion or questions? We have a motion to table this until March 2nd? Would that be April? April the 4th?
That would be my motion.
We have a motion, we have a second to table this until April the 4th. We have a motion and we have a second. Any further discussion? All in favor, say aye.
Aye.
All opposed? Motion carries. Next matter is a consent agreement and school capacity information for Meridian subdivision. That is found on page 29. Mrs. Morris.
This is a proposed consent agreement from Galagetza Homes. Mr. Zandante has purchased this project, and it is 16 single-family homes. It's located off of Roberta Road, right at the edge of Harrisburg. It's actually in the city of Concord. They have platted all of the lots with the city of Concord. The original agreement was written so that when those lots were platted, we were supposed to receive payment within 45 days. We have had a hold on the project. That has not happened. Mr. Zandante would like to go ahead and move forward with the project. The resolution in place and the ordinance in place at the time of the approval of the project requests that $4,034 be paid prior to platting, which means that they would be asked to come in with a lump sum payment. You do have a letter in your information. Mr. Zandante is asking that the payment be moved to building permitting. He is planning on building some of these homes, and he would like for that payment to be moved to permitting so that he can handle the cost instead of incurring all of that cost up front. And he and his wife are here if you have any questions for them.
Commissioner Cruz?
Yeah, I was looking at the capacities, and I see that, of course, we look at the schools, we try to project the schools that are going to have an impact in reducing the figures, and obviously 16 homes are not going to cause that increase at Pitt School Road Elementary School. Is there not any plans for any elementary school in that area to relieve that 140%?
There is not. You can see that the students, some of the students have been reassigned to Hickory Ridge. As far as for the middle school.
Right, middle and high school are okay. I was just talking about the elementary school there.
There are no additional plans for an elementary school right now in that area.
The last thing I saw was overall capacity within the school system is at 91%.
So they could redistrict and get that bubble down.
There's a lot of things that can happen, I'm
Well,
certain,
The
but
91% covers all
that's.
grade levels.
That covers all grade levels, and I think that within each grade level, there's different numbers. Actually, there's different percentages, but I don't think any one grade level is at 100% or greater. I'm not certain, but I saw that report somewhere, and I think I have it PDF'd back at the office. I can email it out, but
Okay, because I believe in there you have Fur, Harrisburg, and Wolf Meadow that are around that school there.
Well, Wolf Meadow's a lot smaller than the others.
Uh-huh.
For Harrisburg and Pitt School Road and even Fur on the other side are all, I mean, that's a lot of density right in there. They did open Patriots Elementary, but that was to help out
Rocky River.
Harrisburg. That really doesn't help out Pitt School Road that much. I think they've used Highway 49 as a boundary because it's such a, a major road kind of thing.
And we have been carrying this particular project on the books since 2007. We were just providing you with some updated numbers.
Right.
The
Well,
consent agreement, two
yeah.
consent agreements were actually approved. They just were never executed for the
Okay, on
project.
this particular project?
That's correct.
so it's
Okay.
already in that 140% number.
Okay, okay.
I think that, I don't want to infringe on them moving forward if that's the case. I mean, it's their property, they can do
I
whatever
agree
they
with
want to
you.
do. But I
16
do
homes
think,
are not going to cause that.
but I do think that if, at some point in time, if this commission, this board wants to rescind the APFO, that this money be held so that it can be returned or whatever can be discussed to be fair to them.
Yeah, was the other thing I was going to bring up about that, was that what we just took to table, the APFO increase.
If we table this, they can't move forward.
Right.
So,
True.
I mean, I've been in favor of them. We've done this before recently on paying when they're actually getting the building permit, and that's all they're asking for is to change. I think
Right.
that's kind of what we said. If they come in, somebody comes and asks us to do that, then,
We've
you know,
done
if you
it.
do it for one, you should do it for all. So I don't have a problem with that, that particular idea of doing it at building permit instead of at plating. Since we've done it for somebody else, I mean, I think we should treat people equally as far as that goes. Your
Excuse me,
comments,
Miss-
though, I do agree with you completely on the
yes,
future.
Excuse me. The elementary schools on that form you're talking about, it's at 92%.
okay. Thank you. I knew I had it somewhere, or I've seen it somewhere.
Moving target.
Any other discussion? Is there any discussion about placing this under, I'm sorry? Commissioner Burridge.
Are they paying the same amount fee for these lots that somebody paid last year?
Nobody's paid any that I know of. Or Mrs. Morris, do you have that answer?
They would be paying the amount from 2007 when the project was originally approved, because it did have, the agreements were approved by the Board of Commissioners. They were just never executed because of the financial situation that the old developer got into.
Yeah, but they weren't agreed to with this buyer now, were they?
No, it runs with the project.
It goes with the project.
Yes, sir.
Regardless of who buys the land, it goes with the project.
Yes, sir. The APF runs with the project.
One other thing, are these lots in the floodplain? They're sitting right there on the river.
I can't answer that question because it's Concord's project. There's a potential that there is floodplain on the property. I would imagine, yes.
But
But
it
Concord
showed-
would control
Correct.
the building permits and make sure that they didn't put a house in the floodplain.
That's correct.
This would-
They have an ordinance, a no-fill ordinance like we do. So they would have to have that actual house out of the floodplain or built with floodproofing standards.
There's, Commissioner Burridge, on page 34, I've increased the thing, and it's up here on the screen, that it looks like here's the FEMA floodway encroachment line.
And that's the open space.
And then there is, down at the bottom, the existing FEMA flood fringe line per firm.
And I believe that 4.3 acres, that's the open space with the development.
Right in here, the 4.3.
Correct.
That's the common area.
Do we normally put these on consent?
We have recently, in the past 6 months, they've been
That's
going
what
on
I was thinking.
consent. If this goes on consent, if this is a decision of consent from the board, I think the motion needs to be moved to the consent agenda with payment at,
Building permit.
right, because what we have it on the agenda right now is prior to building permit. So
I
it
would
needs-
make a motion that we place it on the consent agenda with payment made at building permit,
We have a
per their
motion.
request.
We have a motion. Do we have a second?
Second.
We have a motion. We have a second. All in favor, say aye.
Aye.
All opposed? Okay. Motion carries. Now, under G3 is the proposed text amendment, and that is on page 36. Mrs. Morse.
We were approached a couple of months ago about someone wanting to have a tattoo studio as a home occupation. About that same time, the School of Government put out some guidance related to some litigation that had happened and some court decisions that were made about tattoo studios in relation to the First Amendment. You have that information in your packets. When we started looking at the requests that we had, we noticed that we didn't have tattoo studios as any type of a line item. And in past conversations with the Sheriff's Department, they do tend to look at age-restricted uses as more adult-oriented type businesses. This came up whenever we were talking about the e-gaming situation. So what you have in front of you is a text amendment that proposes to change the list of permitted uses to add tattoo studio as a line item for the GC district and the office limited commercial district. The Planning and Zoning Commission had a lot of discussion about this, and they just were not comfortable with it being added as a home occupation, especially because of the age restriction. We would need to hold a public hearing for this, and I would be happy to answer any questions that you have, but at this point, the proposed amendment is solely to add tattoo studio as a permitted use in the general commercial and limited commercial districts.
Are there any questions for Mrs. Morris at this time?
Susie, I did notice on the, looking down through the text itself of the ordinance, there's a, under home businesses, home occupations, there's one chair tattoo studio. Is that still going to be permitted, or is it in red? Is that what's going to be limited, taken out of it?
I provided you with everything that went to the Planning and Zoning Board.
Okay.
During their conversation, they were not comfortable with it being approved as a home occupation.
At all? So
At all.
that what's in red there would actually be removed from
That's
and
correct.
changed.
So what you all would be looking at is strictly to add it to the GC and LC zone
Okay.
and not as a home occupation unless you are of a different opinion.
Okay.
What is a home occupation?
That's where someone can apply for a permit to have different types of businesses in their house.
What are some of the home occupations that fall under that category?
Typically a home office or maybe a tutoring service, different items that are low impact. We do allow a one-chair barber shop and beauty shop as a home occupation. And there's a list, but they're mostly low-intensity uses where you really wouldn't have a lot of people coming to your house. You more are doing the work there and then maybe going out to deliver the work or going to another place to perform the work.
And you said we'd have to have a public hearing
Yes, we'll have to have a public
because
hearing.
it's a text change.
Yes.
Is there any other questions for Mrs. Morris?
What is the benefit of a tattoo studio?
Well,
Someone is making money as a small business owner.
I don't think any of us on this board, I don't believe, are versed at all on how.
Entrepreneurial spirit.
since it is currently,
Not speaking from, I have none speaking from experience, though I can assure you that from a strange quirk of fate, I have learned a fair amount this year from my entrepreneurial-minded students about gauges which are the holes in the ear and tattoos. Learned a whole lot more than I ever thought I wanted to know or needed to know, but so I'm just picking on you, but that would be the entrepreneurial spirit that I keep being reminded that 18-year-olds are in favor of.
Now, if we were in Columbus, Ohio, at Ohio State, we'd probably have there'd be much more of a need for a tattoo parlor in your home.
Are they any in Cabarrus County now? Or are they just in the
Turn your-
city of Concord?
Turn your mic
They're
on.
mainly in the cities because they want to go where the density is.
No, it's in the city of Concord and Kannapolis,
Yes.
but none in Cabarrus County.
No.
Is
and
that
if-
what we're trying to do, put them in Cabarrus County?
If you,
Make
yes.
them legal?
Yes, and if you look at the map, you'll see that the areas, there's a map in your packet. You'll see that we don't have a whole lot of GC or LC, but we do need to allow that type of use somewhere so
And
that
that's-
it isn't challenged.
That's based on the legal challenge under the
Correct.
First Amendment that
Correct.
other jurisdictions have lost.
Correct.
So if we don't, and somebody wants to put a tattoo parlor in their home, and we don't have it in our zoning anywhere, then we're subject to a lawsuit.
And the lawsuits have been pretty consistent. If you try to zone out a particular type of business that's legal, you're certain to lose in court. And in our jurisdiction, in the county's jurisdiction, there is no specific reference to tattoo parlors. And since the issue has come up, then it went to the planning board for its consideration. So regardless, if it's a legal activity, then you can control it or direct where it occurs through zoning, but you can't prohibit it outright.
So if we can't, I mean, if we can't have any, if we can't stop it, why are we voting on it? Are we just voting to put it in the,
No, not allowed in residential areas.
Correct.
Right, so this is, and if the county attorney wants to, maybe that's best for me to defer to the
No,
county.
you actually, you actually summarized it very well. And I guess the other side of it is that if it's not in our zoning ordinance at all, and someone came in and said, I'm entitled to have a tattoo parlor somewhere in the county, because it's not in your ordinance at all, they could put it in a place where you might not want it to be, namely in some residential zoning classification or even as a home occupation, such as was proposed here. So, at least from that perspective, aside from the other reasons, we need to put it in our ordinance somewhere. And based on, as Susie said, the extended discussion that planning and zoning had about it, because they weren't all of one mind about this topic. They felt that the place where it made sense to have it would be in a commercial zoning district where there would be some amount of density and where you typically see them when they're located within a municipality. That's sort of how they ended up arriving at their recommendation. But there was quite a bit of discussion about whether it should be a home occupation or whether it should be in some other zoning districts and so on. But the bottom line is, unfortunately, the case law is such that we need to have it in there somewhere, or if someone challenges it, we run the risk of them being able to put it anywhere. And I don't think that's where the board would necessarily want to be on this.
can we keep them from being close to school?
You can have limitations of that type, distance limitations from a school or church or some other type of use such as that. They certainly have been approved and allowed for many years for adult-type businesses and other businesses where you're making a determination that that use is incompatible with another use, particularly one like a school or a church. So yes, you can do that. I'm not sure what all the instances are in our ordinance where we do have that, but there are those kind of situations. And I think you have to show that there is a reason for it. And that may well be something that you can show with a tattoo studio. We haven't really looked into that, but I think it is an option.
Jay,
Well, I think a lot of young people now, though, they think it's cool to go get a tattoo, and a few years down the road, they wish they hadn't have done it. And there's a whole lot of things got to be done to get them off. So I think there'll be a limit as to how close it can be to a school.
Jay, can you put the map up there, please? If you look at the map, and you can probably see it better on your computers than you can on the screen, the areas of LC and GC are somewhat limited. It is clustered around Lane Street up towards Kannapolis, depending on the availability of utilities. Correct. Depending on the availability of utilities, they may be required to annex into Kannapolis in order to open the business. There is some limited LC or GC going out towards Odell. That's located around the Odell Fire Station, but again, it is very limited as to what is there. You'll see that there's a piece near the Speedway. That is actually the Little's Mobile Home Park, which probably wouldn't be redeveloped anytime soon. And then the other cluster that you have is really down towards Midland along 2427, where you have existing businesses. So the amount of property that we have that have these zoning designations really is quite limited, but available, in the event that we do have a request.
You have it here in Midland, over here in Midland, right?
Yes, and that is still county jurisdiction, but it is closer to the town limits of Midland than it would be into 2427.
Could you, I know that back when we did these, there's the permitted by right, by zoning classification, where it's just purely a right to develop that, then permitted by standards, and then conditional use. I think what Commissioner Burge may be saying is that is there a way to do it permitted by standard where we would put here's criteria has to be met by even in those zoning areas, criteria has to be met by a tattoo studio to locate in those, even in those areas, where it can be within a certain number of feet of a school or educational institution.
We could do that, and if we were going to do that, I would have to take it back to the Planning
Yeah.
and Zoning Board and maybe have them talk about it. But because we had such limited property where it could go, they were comfortable with it being permitted by right.
Would not also, other thing I'm thinking is, would not also the cost for somebody like that developing that for a tattoo studio be pretty steep in those areas where it's zoned?
Yes, and again, they typically go where the density is and
Uh-huh.
where the people are. So, our locations are probably not the best for that type of business.
One thing I'd be concerned about is if looking at the few locations that this would actually apply to, if you put in a restriction for schools, is it then going to knock out these places? So in essence,
We're zoning them out.
we're zoning them out. I think that's a concern, number one. And number two, the few places that these are located right now anyway, there's enough tattoo parlors, whether they're in Kannapolis, Concord, don't know if there's any in Harrisburg. I don't think the location to the school is going to make it more enticing or not enticing to get one. Because I know there's one there used to be one on Cannon Boulevard, not far from DSS, over in near that Mexican restaurant. I think that was Ink Tattoo or Ink Stir or something like that. It's something we can certainly look at if that's, if that's what your thoughts are, Commissioner Burge. I just think in looking at the distance, I don't want to block out what few places there are available now by putting a distance, and then we're back to square one where we are today and just saying we're zoning them out, and then we're subject to a legal challenge.
Right. I'm fine taking the proposal from planning and zoning and putting it on for a public hearing
Okay.
and going forward. There's very few locations that they can locate in. The main thing when I read it was that I was not in favor of it being a home business.
Yes.
I live on a small street. Certainly my neighbors would be doing that to begin with, but nonetheless, I didn't want to see traffic like that in a neighborhood. So these areas are so limited. I think that if anybody's going to open one, it's going to be in one of the municipalities, and it's really not going to affect us to any great detail, because the municipalities are going to make their own decisions. But I wouldn't want us to be open to a lawsuit for any reason. Nothing personal, but we don't really need to have you working on a tattoo lawsuit. So I would make a motion that we put it on new business and have a public hearing.
We have a second to place this under new
Second.
business? We have a motion, we have a second. Any further discussion? All in favor, say aye.
Aye.
All opposed? Motion carries.
Thank you.
G5 is the memorandum of understanding local government and agents and employees to follow certain Board of Education policies. Mr. Cook. Oh, did I skip one? I'm sorry, communications and outreach. Mrs. Hawkins, presentation of the results of the final. Do you want to just present that at the 17th? Do we have a motion to place this under new business for the 17th to
So
have a
moved.
presentation of the results?
So moved.
We have a motion, we have a second. We have a second. All in favor, say aye.
Aye.
All opposed, motion carries.
Mr. Chairman? just a
Yes.
Point of order, I think our meeting's on the 18th, right?
The
Okay, so
18th,
you-
excuse me.
Yeah, so, yeah, I'm assuming that the clerk's just correcting that, and she puts it in the,
The 18th. Under G5 now, Mr. Cook, the memorandum of understanding local government and agents and employees.
Yes, Mr. Chairman, this document, which is in the agenda, was sent to me by the attorney for the school board as a document that they would like for all of the municipalities within the county, as well as the county, to sign. And this memorandum of understanding basically is just is an acknowledgement or an agreement that the employees and agents of the county would adhere to certain of the enumerated school board policies that are contained in the memorandum. And those consist of the alcohol beverage policy, which is a outright prohibition of alcohol on school properties, tobacco products, which also is a prohibition of use of tobacco products on school property, possession or use of weapons or explosives, a prohibition, that the forbiddance of a registered sex offender from being on school property, and then finally the a dress code or clothing requirement, shirts, pants, shorts, and shoes being required at all times when on school property.
Is this for students also?
I would believe that it presumably is. This MOU does not address the students, it just addresses municipal and county employees and agents who would be on school property. So there were a couple of small changes that I had suggested be made to it, and they included those, and also Al Benshoff had a couple of changes that were also reflected in this document. So we have had some input into it, and aside from that, it's a pretty standard, straightforward memorandum, and it's just asking for the county's cooperation in complying with the school's policies on their property.
Well, what happens, I mean, I see here is if one of the county employees violate this, then it's just where the city manager or the superintendent and the county manager discuss it. Is that what I'm reading?
That's correct.
And the reason why I say that is if they request, for whatever reason, general services to come out there, well, I'm certain general services has a box cutter in their truck. They've got tools and equipment that's equipment for themselves, but if you want to be very strict in definition, could be considered a weapon. I mean, do we get in violation of one of our general services that are asked to go out there? I mean, and then the schools, they're calling roofers to come out and roof their property, which they have weapons on there, talking about box cutters, knives. I'm imagine electricians have different things that they want. I mean, I don't understand why the schools are asking us to sign something when all we're trying, when it's be mature about what you're doing.
Well, I don't know that I can answer that question specifically.
I mean, it's not a it's more of a
Although I
statement.
although I see your point.
I mean-
You know, that,
Is now, if we sign this, now do we set up our employees to get in trouble with a school administrator that doesn't like one of our general services guys that goes out there, and they want to try and get them in trouble in some way, shape, or form?
And Mr. Chairman, I was also wondering if the school board attorney gave you any idea of what the purpose of this is, or why the school board feels like this is necessary?
I'm not sure I can explain what precipitated it. Apparently, there was a request from the school board to the school attorney to prepare a memorandum that just confirms that these policies will be followed. So I assume that based on that statement in an email, that it originated with the school board.
So then I wonder, by extension, are we going to have one that comes from the city of Concord that says we have to enter into a memorandum for an understanding that all our employees that walk on the city property are going to follow all the city council policies?
Well, I don't like this. I don't think, I think this
To me,
is
it's-
overboard.
To me, it's fraught with all kinds of minefields. It's a minefield. I mean, because we say in accordance with their duties, but what if it's off duty? What if you have an employee that goes to a football game on Friday night and carries a pocket knife in their pocket? Would they be considered in violation of this,
Well, let me- I called the school board chair and asked, I had two questions, one for staff and then a response, and asked what the purpose for this was, and if there was a known incident that this was as a result of. And the response was, no, that this was just something preemptive, kind of, they wanted to have in place because, for example, the tobacco products policy is a statewide policy. That is not a local district policy. That is, the state of North Carolina legislature said no tobacco products of any kind allowed on any school property anywhere in the state. So, first of all, I think that would be, I think they're trying to do a policy to make sure that everybody else is aware of the policies that they're under themselves. Second of all, they have general services people who have box cutters on them and who have pocket knives on them, and they're out there doing their job. I see them all the time. So I don't think that that's what the point behind this is. I would say that if there is concern about it, then I would suggest that we table it until we can get some more information from them until next month, just to make sure if there's a basis for it. Second of all, the question I had for staff is, do our general services people go and work on the school property?
Typically, when that happens, it might be on a park or something. From time to time, we have some involvement on school property, very rarely in a school,
That would be my thought, too.
but on school property, yes.
Okay. The second comment that I had is, of course, we have resource officers that are there, and they are excluded from this.
Weapons.
That says it,
Weapons.
on-duty law enforcement personnel, firefighters are exempt from prohibition of weapons because, obviously that's what they have. The other concern that I had as far as the policy goes is, as a general rule, I don't know, I could be wrong, but I don't believe that we ask all of our employees, or do we do a background check on employees to see if we have any registered sex offenders on staff? I have no idea if we do or not, but
Well, when people are hired, there are background checks performed, and I imagine.
which may or may not show up. That much I do know from previous background checks, that sometimes it shows up and sometimes it's in the process and it doesn't show up.
It would seem as though most everything that's listed down here is covered by some other state law.
Yeah, and that's the concern I have, is that this memorandum of this request of memorandum of understanding, a lot of them, there's already a law. It's a felony to carry a weapon on school property. It's a felon to be a sex offender and go on school property. So that if there's already a law there in place, why does there need to be an understanding between the county and the schools? Right, so that
my knee-jerk reaction, which is absolutely has no basis in fact, in all honesty, is that we do have an individual who likes to come and speak for 3 minutes, who has made accusations not against county personnel, but against city personnel, and this may be in direct result of that.
Well,
That's all I'm saying. I would think that's where this is coming from.
then if that's the case, then Cabarrus County should be taken off the memorandum of understanding.
So, if that's the case, then I would suggest that it be tabled for, till the February meeting, to allow the county manager and the superintendent and/or county attorney and the school board attorney to have a discussion. And by the way, when is the next chair, vice chair meeting with the school, with Cabarrus County Schools? Table it until after that meeting, if need be, so that there can be a better understanding of the reason behind this, so that we would have a chance to talk to them about any concerns.
One other comment I would like to make is that, in principle, I'm opposed to enforcing policies of another governing board, and I don't think it's appropriate.
And that would be a reason to have a good dialogue with them before just saying no.
We have a motion to table this until February 7th. Is there a second to that motion? We have a motion, we have a second. All in favor say aye.
Aye.
All opposed, motion carries.
I would ask that the county manager give the superintendent a call, if you don't mind, and either the chair or I could talk to the school board chair and
Okay.
talk about any concerns that we have.
G6, Emergency Management Hazard Mitigation Plan. Mr. Smith.
Good afternoon. I have before you a request to hold a public hearing and then adopt by resolution our updated hazardous mitigation plan. We have worked with our Commerce Department and the towns of Midland and Mount Pleasant and Harrisburg to update our plan. The original plan was written in 2004 from a requirement from FEMA and North Carolina Emergency Management. We have to have this plan in place to be eligible for any disaster funding if we should have an event here. We have received a conditional approval from FEMA, waiting adoption of our boards. The 3 towns have already adopted it by resolution, so it's just up for us to hold a public hearing and adopt it by resolution, and then we can turn that in to get our final approval from FEMA. Just a note, the city of Kannapolis and the city of Concord has their own plan, and Kannapolis is part of Rowan County's plan. That's why they're not included with ours. So we are asking again for a public hearing and adoption by resolution of this plan. And if I can address any questions, I'd be glad to.
Any questions for Mr. Smith? This is a plan that we adopt every year?
5 years.
Every 5 years?
Yes, sir.
Okay. And this does not affect any property rights, anything with people? It's just if a hazard, we just identify the natural hazards and then what we're going to do if a natural hazard occurs?
Right, and strategies to mitigate the effects of those hazards. And again, this keeps us compliant with FEMA so that we are eligible to receive federal and state disaster aid.
Okay. And for Commissioner Burge and Commissioner Meismer, I believe that the only time that in the past 4 years we've had, it's been very rare that we've not applied, but we've fallen under that category of possibly receiving funds, and that was with flooding and icing.
And yes, sir. Yes, sir.
And I think that was only twice that I'm aware of.
Yes, sir. That's correct.
So, is there any other questions for Mr. Smith? Since this is a public hearing, do we have a motion to place this under new business for January the 18th?
So moved.
We have a motion, we have a second? We have a motion, we have a second. All in favor, say aye.
Aye.
All opposed?
Thank you.
Motion carries. Thank you. Next matter we have is on page 222, the Fair 2010 recap. Unless somebody would like to hear about it today, I think that it would be appropriate to place this under new business for January the 18th. Do we have a full report? We have a motion, we have a second. All in favor say aye.
Aye.
All opposed? Motion carries. Under page G8, which is 224, is the first-time waiver of occupants tax penalties, Great Wolf Lodge, $10,200.96. Mrs. Dubois.
Yes, on April 19th, 2004, the board put a policy in place that allows me, as the finance director, to waive a penalty up to $1,000 for the first offense for a hotel related to occupancy tax. I would have waived this one had I had the authority. It was an administrative error at their home office, and this is the first offense that they have. However, the penalty exceeded my limitations, so I have requested to put this in front of the board. Like I said, I would have done this had it been under my dollar limit based on the postmark of 1 day late.
Any questions for Mrs. Dubois?
I'd make a motion to put it under the consent agenda and allow the waiver.
Okay. We have a motion, do we have a second?
Second.
We have a motion, we have a second. Any further discussion? All in favor say aye.
Aye.
All opposed? Motion carries. Page 227, G9, a request to waive the fund balance transfer to capital reserve fund per board policy FY 2011. Mrs. Dubois.
Yes, we made an amendment to our policy due to the economic conditions to allow us to use fund balance in an economic environment when revenues are well needed. And at this point, we are requesting for the board to make a waiver to allow us not to transfer our excess 15% to the capital reserve fund so that we can use those monies to balance the budget over the next several years. The 5-year plan that the board adopted in the budget package for last year used around $9 million of that money, and we will be addressing budget shortly and having some decisions to make on how we'll be addressing the new expenditures for next year and whether the board would entertain a property tax or a quarter-cent sales tax, and should those options not be viable, then we may need to use some excess fund balance. I have a schedule in here to provide. Well, first I have the policy in here for the 2 new commissioners where we had made some changes about using fund balance for economic downturns. And then, like I said, I'm requesting a waiver this year. And to also let you know, we've had discussions with our bond counsel, with our rating agencies related to issuing debt and bonds. And in our discussions, as long as we maintain the 15% fund balance during these economic conditions, that utilizing fund balance would not be held against us at this point in time. So that's why this request is being made. But if you go to page 230, you'll see the calculation showing how much excess fund balance that we will have at the end of June 30th should you not make this transfer, and that would be approximately $22.9 million. The board appropriated $1.7 million of it in, I believe it was either August or September of this year, to continue ongoing projects from the previous fiscal year. We'll be discussing self-insured health insurance contribution that needs to be made for the 2012 budget year. And as I stated before, it's $9.5 million that you had in your previous 5-year plans, and we'll address some changes that will need to be made to that because after the budget was adopted by the county, the state took away part of our lottery money, so we're going to have to make some reallocations in that area, which would affect the use of fund balance. And then we have some estimated projects that can either be funded by the fund balance excess or from capital reserve. And that would be the Bethel School demolition, the Board of Elections old buildings demolition once they move, and some remodeling of space at the Cabarrus Health Alliance once they move out into their new facility. Discussions of moving some other departments in that facility with them to where we will not have to rent the space from an outside vendor, and one more estimate of helping to fund the post-closure costs for the landfill, because we've had a decline in revenues of the 30-year mitigation that we're required to keep a liability intact for. We'll have a shortfall of $2.5 million that we will need to fund from our general fund. So that's pretty much some of the uses that we have in place right now, and leaving about $5.1 million not designated at this point or not suggested for use. But like I said, there will be some changes to the 5-year plan for next year based on the lottery changes. So utilizing the excess fund balance is going to be very important over the next 5 years. So I would recommend that we actually do the waiver again this year so that we'll have these monies available for what we intend to do with our budget during this upcoming year.
Any questions for Mrs. Dubois?
Just I guess a couple of comments, because I asked this question actually at our budget meeting, our budget meeting, our last meeting when we had our financial report. And I know that I was back when we first came up with the transfer policy back in 2005 was when it just went to 2 or 3 or more years of, using it to create, I guess, the fund balance to create and cover a large structural deficit that was occurring. And then we did that policy to prevent that from happening in the future. And I don't have a problem. I think this is, good because they've used the example of what we've got at Wasac. We have a thing called a rate stabilization fund. It's actually in the statute that it formed Wasac, where there's a certain percentage of the budget every year that's put aside. And what it does, it prevents an upswing and downswing of the rates charged to the cities for Wasac's fees by using that money then to balance, kind of even out the revenue stream from year to year. And I wondered about it here. I don't think we can do something that formal, but with this of some criteria like that, it's, we would not use this in the future to lower the tax rate, but only to prevent a tax increase. We would use it to, it would be a certain limit on how much we could use per year, say a 1 to 2 cent deferment, equivalent, and over maybe no more than 4 or 5 years, because that would take care of any kind of economic downturn, and would prevent us from this board or future boards. We'd have to make a deliberate decision in whether or not we wanted to allocate, if we had $10 million, all $10 million of it in 1 year to cover a budget deficit, because that to me is more of a structural issue that we've got to deal with. But the 1 or 2 cents per year, I think this would be a great way for us to lock in a tax rate, this way, and prevent having to have a 1 cent tax increase 1 year and then drop it back the next year, and then, those kind of things.
The conditions of how you want to use this money is totally up to the discretion of the board, but we as a staff cannot appropriate fund balance without your authorization either. But if any conditions that you would like to put in place is definitely the prerogative of the board. We just didn't want to send it to the capital reserve fund, because once it makes it to the capital reserve fund, it can only be used for capital projects and cannot be used for operations. And didn't feel comfortable at this point not knowing what's going to happen over the next several years. Rather be safe than sorry.
And we did this before, and I think it's worked well to do that. And what I like about it is that we would only make this designation for this time. So next year, if the case arises, you would come back to us again. So it's not like we're making a policy change.
Right.
We're in essence suspending a policy for 1 year. So for that purpose, I think it makes perfect sense in this economic time. I think it was on the radio this morning. Technically, we're not in a recession. Did y'all all know that? Technically, we haven't been in a recession since August. No, statistically, we're not in a recession, but the majority of the people would say we are still in a recession. So, I think that's just whether you want to go with mathematics or if you want to go with what people are really acting like and feeling. So I like the idea of looking at this annually and making the determination. And so I'm good with doing the waiver and using it for, I'm sure we'll discuss all of these items during the budget process anyway, but.
All except for the first one, because you've already acted on that one.
Right, that's what I meant.
And the waiver is consistent with the amended policy that the board adopted.
Right.
And in a time of uncertainty like we are in now, it's when we think it's particularly prudent to preserve the board's flexibility in the future. The state's facing a $3.7 billion shortfall. It's hard to imagine that somehow the counties are not going to become involved in that.
And you said that with such nice politically correct words, too, because it wasn't the word that I was thinking of, but I agree with you. Would this be good on the consent agenda?
The consent agenda would be fine.
Yeah.
Before we get to that, Ms. Dubois, can you just give a brief explanation as to what the importance of 15% as opposed to what the local government commission request or mandates, so that we all can get a refresher on that, please?
Okay, there's an administrative policy that the local government commission has that states that every county and jurisdiction, city, town is required, it's an administrative policy, so it's not a law, but that it's prudent to have at least 8%.
8% of what?
8% of your expenditures set aside in your savings account, that's what I'm gonna call fund balance, in your savings account for that rainy day that you might need to be able to meet your expenditures. We did an analysis of cash flow, and several years ago, we came up with a 15% fund balance policy stating that based on our cash flow, and that's the revenues that come in versus the expenses that go out, that we felt like we needed a 15% fund balance policy. Our cash flow has changed a little bit over the years, and the recommendation for a government our size at this point in time is 20%. But 15 is sufficient for Cabarrus County and based on the way things are taking place. So we've not requested to go through an evaluation process to see how that's changed, because over the last several years, there have been some changes in the way the real estate agents or the escrow agents pay their property taxes. They're actually paying 1 month early than they used to in past years. But we have felt very comfortable. We've not had any issues maintaining 15%, and we've never felt stressed out when October and November get here and worrying about whether we can actually pay our bills. So we felt like leaving it at that 15% was comfortable for us, even though like jurisdictions were at 20. And with a lot of the refinancings of debts that we have pushed some of the principal payments that used to be in September, which are now in March. And we've flipped them where the interest is now due in the fall and the interest and principal payments due in the spring. So that's affected our cash flow. So we feel very comfortable with how that's established, but that's our emergency fund for Cabarrus County, which what somebody would have in their personal finances at home.
Okay. We have a motion to place this under consent agenda. Do we have a second? We have a motion, we have a second. All in favor say aye. All opposed? Motion carries. G10, Soil and Water, approval of North Carolina Clean Water Management Trust Fund grant contract. Mr. Testerman.
Good afternoon. I think what I'm here to bring before you would be perceived as good news. We applied actually 2 years ago to the Clean Water Management Trust Fund with the state of North Carolina to get some monies to retrofit the stormwater management system at Coxmill Elementary School. And those monies were actually recalled by the governor, as I recall. We've continued to pursue that grant, and it has come to the point that we've actually been awarded some money from the Clean Water Management Trust Fund, and so they have now presented us with a contract for the county to approve so that that work can proceed forward to get the improvements designed and then get construction underway. So as you've already seen, the total cost of the contract is for a total project $953,403. Like most of these grants, it requires a match. In our case, we've been able to do that mostly through in-kind matches, and the biggest chunk of that is the value of the conservation easement on the 100-year floodplain that you all took action on some while back, and that process is moving to completion in the very near future. So having said all that, I would entertain any questions that you might have.
Any questions for Mr. Testerman? What are the in-kind contributions from the schools? They're not having to come up with $72,442.
That actually needs to be worded better. I'd already flagged that after this process had gone forward. That money, that particular line item in the contract budget represents a, what are we calling that? A stormwater wetland at Coxmill Elementary School. It was like a detention basin that was there from the work that was done when the school was constructed. It's grown up in weeds now. There's sediment in it. We have, as most of you would know, the Conservation District has 2 pots of money from the state for cost sharing, and so we had entered into a contract with the school system to retrofit that one, and so we're just basically putting into this contract a turnkey job for that one BMP to be in place. And we worked with Baker Engineering to prepare the grant proposal, and so the $72,000 was their figure that they came up with for what the value of that BMP would be if they did it. The money there would be from the state in the form of a reimbursement to the school system, and then it would be staff time from state employees and from county employees. So Amy, Daniel, and myself in my office, our salaries, gas, mileage, will be documenting all that. Hopefully we'll come pretty close to $70-some thousand.
Of the 72,000, Cabarrus County is responsible for 25% of that, and then you got your grant from the state for the other 75%.
Actually, the school system would be responsible for that. The applicant was the school system, so they would come up with, they actually pay for all the work to be done, and then they're reimbursed by the state at a 75-25. So they would be carrying theoretically 25%. The state would be paying for 75% of that.
Any other questions? We have a motion to place this under the consent agenda. We have a motion, we have a second. Any further discussion? All in favor say aye.
Aye.
All opposed? Motion carries.
Thank you.
I believe that covers our agenda for today. Is that correct, Mrs. Honeycutt? We do have reports, excuse me. The Economic Development Corporation quarterly report will be given to us in January on the 18th, I believe. Is that correct, Mr. McDaniels, Mr. Cox? And we have any updates from the different liaison committees that we are, if we can talk about that today if you'd like. We can talk about that on the 18th. I do want to call everybody's attention. I can give y'all or forward you on some information I've gotten from the Convention Visitors Bureau or Board that I'm a liaison on. Every month we get a comparison about where Cabarrus County ranks in regards to the region, in regards to the region as in we compare ourselves to Mecklenburg County, we then compare ourselves in the state, and then there's a comparison to other counties our like size in population in regards to tourist attractions, that kind of thing, so we get an idea about the country. And wanted to let everybody know that we are holding our own, if not a little bit better than Mecklenburg County, the state, and in about 2 of the 3 different other areas we are right at, if not exceeding, an average daily rate as called also a RevPAR. So, you know, the events that are coming into Cabarrus County are helping out the hoteliers, which in turn is what Mrs. Dubois was talking about earlier in regards to the occupancy tax rate. So there's a lot of things going on there positively in regards to, and it's on a month-to-month, so we get an idea about where we are throughout the month, but they're doing a very good job out there. So that's all I have in regards to one of the boards that I'm serving on. Mr. Day.
I did want to mention one thing I found out about, more information on today. You may recall the board some months ago approved auctioning off the property of the old Bethel, former Bethel Elementary School. There was a minimum bid set of $200,000. There were no bids, so there was no sale. We have pursued demolition and have gotten a response to a request for proposals for asbestos abatement, which would be required prior to demolition. The cost for that plus demolition far exceed the $200,000 minimum. I've spoken to a woman in the Midland community who made me aware of a fundraising effort that's going on there to purchase the property. My suggestion and recommendation would be to once again attempt to auction the property, but without a minimum. And I can notify this group that they have another opportunity, and this time it wouldn't be quite as onerous an opportunity as it maybe was the first time.
Commissioner Cruz.
I move we put that on the consent agenda to reopen bidding with no minimum bid.
Any further discussion? We got a second?
Second. Do you have any idea of what they might be thinking about? Just, and you can
I don't
answer
know.
that later if you want.
I don't know what effort, where that group is in its fundraising effort, but I can assure you, whatever they pay for it would be a better deal for the county if they buy it than for the county to remove the asbestos and demolish the structure.
Mr. Cook?
Yes, I was just going to point out that the way that was auctioned, or to be auctioned before, was not an absolute auction. It would require that the high bid come back to you for approval. I assume that's what you're talking about in this case as well, that it wouldn't be
Yes,
an absolute. You just see what the highest bid is. There just would be no minimum.
correct.
How much land goes with that school?
It's approximately 12 acres, as I recall, does that sound right?
I mean, we have to do an upset bid process anyway.
11 acres, I'm sorry.
Didn't the people in Midland want to use it for something one time? Didn't they want it? Oh, I thought they did.
Well, there were various groups.
They wanted to use it.
That had interest.
They
in
wanted
the
us
property.
to upfit it.
Pay for it.
Yes, sir. Yes, sir.
Be better off to give it away.
Well, yeah, that's exactly right. Well, we've had some estimates, and clear estimates of asbestos abatement, lead abatement, and demolition will exceed well over $500,000 of our expense. So if we go with an absolute auction as is, then we would not have to incur that expense.
Yeah, the question I just asked that I don't think anybody heard was, I asked if we had to do an upset bid process, and the response is no, because it would be an absolute auction. So
Right.
a lot of things we do, you do have to post and have the upset bid process.
Well, it's not technically an absolute auction. It's just it's an auction without a minimum. So you just see what bids you get in, then you decide whether you want to accept it or reject it. And if you decide you're okay with the high bid that you receive, then you can accept that, and that becomes your contract.
The upside bid is another process that's available. It's a very cumbersome.
Yes, it is.
What-
I guess the only other question I had, which I don't expect an answer now, is that the property's been sitting there for a number of years and continued to go down. Let's be optimistic and say that it is sold to somebody. Can we put a requirement that within a certain amount of time, they would have to do something so that it doesn't? Our concern has been vandalism, somebody being in there and stairwell collapsing and there being injuries. I know it wouldn't be our responsibility at that point in time, but if we sell it to somebody, then I would want to make sure that there's no way that anybody can come back to us and say, well, it sat for another 10 years and gotten even worse and somebody gets hurt. Does that make sense? And I'm sure that you would consider all of that with anything that we sell in property.
I think that we can do that contractually. The part that might be difficult to enforce is the part that would impose upon the new buyer a time limit to do those things. And if they decide that for economic reasons or any other reason not to do it, then we might be, what would be our effective remedy?
And I might suggest that since it's in the town of Midland's jurisdiction, then it would be the town's responsibility to enforce its code requirements. So if the property were not brought up to meet their minimum codes, then the enforcement would be a process that the town would take.
But we would make sure that in any transfer that there's no way that anybody can come back on the county.
That's correct, yes.
Caveat emptor. We have a motion, we have a second to place this under consent agenda. All in favor say aye.
Aye.
All opposed. Motion carries. I believe that conducts all the business for the day.
Chairman, one other
Commissioner
thing,
Cruz.
back on the APAC, there is a vacancy on the APAC. Dr. Roberts, our veterinarian, has resigned, so we need a veterinarian on that committee. So I'm saying this is kind of a public appeal, and I'll do it again on the 18th. If there's any veterinarians that would like to serve, we wanted to serve on that committee, then by all means, they need to just contact Ms. Honeycutt and give an application in to apply for,
Okay.
be appointed to the committee.
Anything else? We have a motion to adjourn.
So move.
Well, all in favor say aye.
Aye.
All opposed. Motion carries.